Hey guys, welcome to my Lear classes. This is Ganesh Pujari, and in my two previous videos we have discussed administrative discretion and judicial control or review over administrative discretion. In my this video and my next video I am going to discuss two important doctrines. They are doctrine of proportionality and doctrine of legitimate expectation. Both the doctrines are very important when it comes to administrative discretion. Why to waste time? Let's get into the first slide to understand what is doctrine of proportionality is all about. There is one famous proverb in Kannada which says Gubbi Mele Brahmastra. That means to kill a sparrow, somebody is using Brahmastra. That means Brahmastra is one of the biggest weapon used in Mahabharata war. And if somebody uses that to kill a sparrow, how does that sound? That is out of proportion, right? The same is in English also, saying that cannon to shoot a sparrow. That is too much of proportion, like out of proportion. This doctrine goes in a similar line. To understand the doctrine, let us get into the next slide. Doctrine of proportionality is not part of the any constitution or any law. It is a doctrine which is developed over a period of time and it is originated in Europe. In Europe, primary importance is given to the doctrine of proportionality as judiciary is the primary reviewer of administrative actions there. Under English law, this is treated as a part of Wensbury principle, which I am going to explain the entire case law for Wensbury principle in my future slides. It implies that cannon should not be used to shoot a sparrow, as I said in my previous slide. There should be balance between means and ends. That is the main purpose of this entire doctrine. The administrative authority, while exercising its discretionary power, it should always apply sense of proportion. There should be a proper balance must be maintained between any adverse effect which a decision may have on the rights, liberties or interest of the persons and purpose which it pursues. If that is harming the rights, liberties or interest of the persons, then there is no meaning of having such authority decisions. That is why this doctrine is utilized. Basically, this doctrine is concerned with the priorities of decision making. Excessive penalties are to be avoided. That is the main thing. There should not be excessive penalties which needs to be avoided, and available restrictive alternatives are to be adopted. Instead of giving excessive penalties, if there are any restrictive alternatives are available, then those needs to be utilized. Over and above this is, if any administrative authority takes such glossary misappropriate and more serious to the nature of misconduct, then such decision is arbitrary and hence subject to judicial review. There you have four important terms, that is grossly misappropriate from the administrative discretion, which is more serious to the nature of misconduct, and such decision is considered as arbitrary and the same is subject to judicial review. Those are the important terms you need to remember. And when it comes to Indian context, the concept of shockingly disproportional is used by the Supreme Court in many of the cases. This is the secondary review only for the common laws. This is not primary review as far as like Europe countries. Only when decision is arbitrary or strikingly disproportionate or extreme case of perversity or irrationality or shockingly disproportionate, only during such cases the judiciary will intervene. Otherwise, the administrative discretion will always be respected. In case laws, I will explain how these terms are used. With that, let's move to the next slide. One of the most important case law that you should write in the exam is Associated Provincial Picture Houses Limited versus Wednesbury Corp, because this is also known as Wednesbury principle under English law, which is like the doctrine of proportionality under their law. Now the fact of this case is, in 1947, Associated Provincial Picture Houses was granted a license by the Wednesbury Corporation in Staffordshire to operate a cinema on condition that no children under 15, whether accompanied by an adult or not, were admitted on Sundays to watch movies. How they have given this order? There was support by two other laws, which are Cinematograph Act 1909, which said cinemas could be open from Monday to Saturdays but not on Sundays. And under a regulation, the commanding officer of military forces in a neighborhood could apply to the licensing authority to open a cinema on Sunday. So this gave the power to authority to run the cinemas only from Monday to Saturday. But however, there was an exception given to the authority. The second law, which is the Sunday Entertainment Act 1932, which said legalized opening cinemas on Sunday by the local licensing authority subject to such conditions as the authority may thinks fit to improve. That is very important. What? Subject to such conditions as the authority may thinks to fit improve after a majority vote by the borough. Now, Associated Provincial Picture Houses sought a declaration that Wednesbury Corporation was unacceptable and outside the power of the corporation to impose. Now, what did they say? They have given permission on Sundays to run the movies, but only thing they have restricted the children under below 15 to not to attend the movies, though they are coming with adults. So that was the condition put by Wednesbury Corporation, which was supported by two other laws, Cinematograph Act 1909 and the Sundays Entertainment Act 1932. And what is the judgment? The court held that it could not intervene to overturn the decision of the defendant simply because the court disagreed with it. To have the right to intervene, the court could have to conclude that in making the decision, the defendant took into account factors that ought not to have been taken into account, or the defendant failed to take into account factors that ought to have been taken into account, or the decision was so unreasonable that no reasonable authority would ever consider imposing it, or the court, these three conditions it discussed, and said that the court held that the decision did not fall under any of these categories and the claim failed, because these two laws ensured that the authority has the power to make such discretion and they were within the limits, so court couldn't intervene in the same. That is all about Wednesbury principle or the case law on Wednesbury Corp. With that, let's move to the Indian context. When it comes to Indian case laws, you have to mention two categories of case laws. The first being in favor of administrative discretion, where judiciary supported the administrative discretion. There are three important case laws: Om Kumar versus Union of India, Canara Bank versus V.K. Avasthi, and Union of India versus R.K. Sharma. In all these cases, court upheld the discretion utilized by administrative authorities. Whereas I have brought three important case laws which went against the administrative discretion. The first case being Hind Construction Company versus Workman. What happened in this case is few workers went absent from duty thinking that a particular day was holiday. They did not turn up to work thinking that that day is a holiday, and what was the punishment given to them? They all been terminated from the company, but the judgment was it was held invalid because that is too gross punishment. In the second case, which is Ranjit Thakur versus Union of India, what happened? An army officer did not obey the lawful order of his superior. It was his duty to follow the order given by his superior. However, he did not obey the lawful order from his superior. And what is the punishment? 1 year rigorous punishment along with dismissal from service and unfit for future employment. And court felt that it was invalid as grossly disproportionate level of punishment is given, which was not okay. In the third case, Sardar Singh versus Union of India, you must be aware that the army guys will get to buy certain number of liquor bottles, and during that times they were allowed to buy 4 bottles of rum. Maybe his friends have asked for too many bottles of rum, so he bought 11 bottles of rum. For that, what is the punishment? 3 months rigorous punishment along with dismissal from service. And Supreme Court set aside the order, saying that the order is arbitrary and punishment is too severe. So these are the 3 cases where you can refer the doctrine of proportionality which went against the administrative discretion. That brings an end to this particular video. In my next video, I am going to discuss the doctrine of legitimate expectation. Thank you so much for subscribing me. Please like, share and comment my videos. All the very best for your exams, and thank you so much for watching me.